Your Honor, we can perhaps Wadir just supplement from the report if that would help.
Yeah, that's fine. Go ahead.
Okay, Your Honor. So I think we already established the venue and the time and location.
Yes.
So the victim in this case is an Uber driver, and according to the police report, Mr. Copeland, along with some other individuals, were in that ride and attempted to pay the fee with partially with the credit card, which was declined. The victim stated that he was assaulted at that time. This is after he regained consciousness. He was apparently beaten unconscious and suffered, I have to find the exact injuries. But he was injured to an extent that he did not remain conscious immediately afterwards.
So, sir, is what was just relayed, is all of that correct?
Yes.
And so at some point that you push this individual, and there would have likely been other blows to that individual, you're not disputing that the individual went unconscious?
Yes, he did.
He did? Okay. Yeah. All right. Counsel, with that, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor, people are satisfied.
Defense is also satisfied.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be March 1st, 2020. Well,
I had to put some water in my hair.
is he being held on anything else?
Yes.
He is.
And I believe that the bond in this case has already been set so that it
That's
will
where
turn
we're at.
into a PR once
That's where we're at in
other
our
matters,
relationship, people.
are taken care of.
Yeah, right. So I'll set his sentencing for March 1st, 2023, 9 a.m. All right, that's before me.
Thank you.
And what we're going to do real quick, Mr. Copeland, is I'm going to put you in with our probation department so they can get some information from you, okay? I'm going to start that process. All right, you'll go into a breakout room with them. All right?
Yeah,
Okay, thank you, young man.
you too.
Okay, Reverend and Little John.
Court calls the case. People
Morning,
versus Kayvon Little John Lewis.
Rachel McDuffie for the people.
I do not have this defendant checked in.
Kayvon Little John Lewis. All one person. Not here. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue, what's the end of this week?
The 27th.
The warrant will issue January 27th, 2020.
Thought I'd throw an intro in there.
People versus
After some
Cody.
people showed up.
Is it Rockbot?
Rachel
Cody
McDuffie for the people.
Rockbot?
Not have it checked.
Okay. They are not here. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. 10% privilege on that. That will issue January 27, 2023. Court calls the case of the people versus Angela Spivak.
Rachel McDuffie for the people.
Good morning, Your Honor.
My first meeting.
Good morning, Spivak.
We
Ma'am,
gotta
you
get a
are
nugget here this
before the
morning.
court on two charges. Two-count misdemeanor complaint. The complaint alleges that on or about September 15th, 2022, location of 6875 Napier Road in Salem Township, Washtenaw County, State of Michigan. Count one alleges that you did operate a motor vehicle while intoxicated with an occupant less than 16 years of age in the vehicle. You understand the nature of that charge, ma'am?
Yes, Your Honor.
Court should advise you that that is a misdemeanor, carries a maximum penalty of up to $1,000 fine plus court costs, not more than 1 year in jail, 30 to 90 days community service, or both. court could order you to pay the cost of the prosecution, any rehabilitative services the court deems necessary. The court could also order forfeiture of your vehicle. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
Count 2 alleges that at that same date and at that same location, and it really is it alleges the charge of operating with a high BAC, and it indicates that on that, you understand that charge, ma'am?
Yes, Your Honor.
Good morning.
All right. That is a misdemeanor, has the same other penalties that I just described, but the maximum jail time on that is 180 days and up to a $700 fine plus court costs. You understand that?
Yes, Your Honor.
All right. First question I have for you, ma'am, is do you wish to be represented by an attorney?
I get Jamie pants
Yes, Your
on.
Honor.
This is a public defender case.
Thank you. Assistant
Yes,
Public
Jamie.
Defender Melissa Kleeman on behalf of Ms. Spivak.
Thank you.
And she stands mute and waives the formal reading of the charges. We are asking for a PR bond and an adjournment of the pretrial.
Brendan, having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to February 14th, 2023, 9 a.m. The alleged VAC in this matter?
Your Honor, and if people would like to be heard on bond on some additional concerns as well, that VAC is 0.202.
202. All right. As to bond.
Your Honor, the allegations in this case are extremely disturbing and concerning to the people. This is not just a typical case of driving while under the influence of alcohol. The allegations in this case are that defendant with the minor child of 10 years of age in apparently the passenger seat, not properly secured either, stopped to purchase the alcohol and then asked the minor child to hand her the bottle of alcohol and was drinking while driving and operating the vehicle.
Oh,
Then
no, you didn't.
got into the crash, which totaled the car, and proceeded to walk out and attempt to walk home on foot in the wrong direction.
No.
So there was an extreme risk of danger to herself, her child, and everyone else around her at that time. But to drink while operating the vehicle and
No, we're not doing this.
is extremely concerning. So we are requesting a scram tether, although the court was probably going to
Turn yourself into jail right now.
Defendant's bond in this case at a $25,000 personal recognizance bond.
Morning, Biggin.
I'll order standard conditions, including no assaultive behavior. Ma'am, there is to be no possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Indeed.
Yes, Your Honor, but I do have a question.
Yes, ma'am.
I have been using marijuana recreationally to help with the pain caused from that accident. I have 2 crushed vertebrae.
Do you
And I don't-
have a medical marijuana card?
I do, but it's expired.
Then you need to get a new one. You can't use recreational marijuana at this point.
Yes, Your Honor.
Treat mental health with marijuana. Only thing is going on is that
Department of Community Corrections for placement on a scram alcohol tether. You are to report to Community Corrections within 24 hours. You understand that, ma'am?
Yes, Your Honor.
All righty. Anything further?
How do I get a hold of this company?
Community Corrections?
Yeah.
Do you have something to write with? Let me give you a phone number.
Okay.
Area code 734 973
Mm-hmm.
4520.
Yeah.
Okay.
She's right.
All right.
I mean, with respect to the
Thank
medical
you.
stuff, she's right.
Thank you, Your Honor.
Let's face it. Let the cascade of
For Gulf's case, people versus Kent
drinking
Robinson.
comments come.
Rachel McDuffie for the people.
Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Robinson. Mr. Robinson, could you please unmute and state your name for the record?
Robinson.
Thank
Oh,
you.
there he is.
Your
All right,
Honor,
what are we doing?
Mr. Robinson would like to plead guilty as charged in this matter. I will state that he is going to be in custody, I believe, until April. And so he was hoping that he could get sentenced and have this run concurrently.
And here's to
I would
you,
have to
Mr.
have him
Robinson.
assessed. So we could try to get him sentenced. Okay, I already have a bond on him, so
There
he's
we
getting
go.
credit,
Juris
Okay.
Doctor.
but we have to go through the assessment.
And I
Oh,
did
yes.
explain that to him.
So he's gonna plead guilty as charged?
Yes.
All right, sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name for the record, please.
Ken Robinson.
All right. Mr. Robinson, it is this court's understanding that you are going to be pleading guilty to the offense of operating with a high BAC second offense. That
Yeah.
is a misdemeanor, punishable by a fine of between $200 to $1,000, 5 days to 1 year in jail, 30 to 90 days community service, or both. The court could also order any rehabilitative programs the court deems necessary, or and order you to pay the cost of the prosecution or the cost of any emergency governmental services and mandatory immobilization of your vehicle. You understand that, sir?
Yes.
You're welcome, Sandy.
Understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, that you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
I mean, this seems like a
Yes.
no-brainer.
Are you on probation or parole?
He's already sitting. If he can run it concurrent, let's do it.
Leo was on probation. But
You're on
now,
probation. Let me
Yeah.
ask it this way. Were you on probation in March of last year?
I don't know.
Yes.
I don't know. I
Okay.
literally was having
I
coffee
have
and
to
watching
advise
this.
you that this could be a violation of
Let's
that
do it together.
probation. As such, that court that you're on probation to could sentence you to the maximum allowable under that charge by entry of this plea. You
Morning, man.
understand that, sir?
Yes.
And understanding that, do you still wish to plead guilty to this charge?
Hi, Danny.
Yes.
Has anybody promised you anything other than what's been stated here? Well, has anybody promised you anything?
Oh, I'd,
No.
Get you to plead guilty
I'd
to
put
this
water
charge?
in my
All
hair.
right, anybody
Let's
threaten you or
go
coerce?
straight up.
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Stop it.
Yes.
I am stone cold sober having a cup of
On
coffee.
March 24th, 2022, at the location of Wired Road near McIntosh Road, Superior Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
Okay, did you have something to drink?
Yes, I did.
Okay, all right. Sorry, I didn't mean to use all those big words.
No, you all right. You all right.
Hair watering brigade.
What'd you have and how much?
Honestly, I ain't gonna
Almost
lie
like
to you.
the
I don't remember at that time. It's been some time, but I was in the wrong for drinking and driving.
All right. So as you were operating this car, did you get stopped by the police or was there an accident?
I got stopped.
Okay. Do you know why they stopped you?
No, I don't remember.
Okay. But you were ultimately arrested. Is that right?
Yes.
And were you taken to the police station or the hospital for a blood draw? Looks like you went to the hospital.
It said, okay, I went to the hospital because I ain't corrupt. I wasn't born in the thing form.
Gotcha.
So we took-
Okay. And they took your blood. And do you recall what the results of that blood draw were?
I think a 2.7.
That's
Okay,
2.272.
2.72.
Pretty close, yeah.
All right.
That's good. That's good.
And
healthy
you don't
thoughts.
have any reason to dispute those blood test results, do
Shouldn't be
you?
driving at that point.
No,
No, no.
I'm
that's
sorry, I
too
didn't hear
far.
you. You broke up there.
0.27. I was
No.
feeling about a 0.27.
Okay. And had you previously been convicted on or about March 14, 2017? March is not a good month for you. March 14, 2017 in the 14A District Court of operating while intoxicated.
yes,
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor, people are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea of guilty to this offense. Defendant is referred
odds
to on
march.
sports if we need to do it that way. For an alcohol screening and assessment in the victim's impact panel. Sentencing, hang on. Sentencing in this case will be set. Do we have March 1st? So, all right, we'll see if we can get him in earlier. He's not set to be released until April. Is that
second,
what you would? Okay.
That's my understanding, yes.
yeah, April 2nd.
Here's what I'm gonna do so that we can, your time is running on this, so we're okay on that. But so if he's not gonna be released, so then I'll set his sentencing March 1st, 2023, 9 a.m. Okay?
Thank you.
And Mr. Robinson, sit tight for a minute. I'm gonna put you in with my probation department in a breakout room so they can get some information on you so we can start the process, all right?
Yes.
All right, thank you, sir. Court calls case, People versus Jeremiah Stanley.
Rachel McDuffie for the people.
Jeremiah Stanley? Not checked in. Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege on that. Warrant will issue January 27th, 2023.
Come on, we need some defendants.
Court calls the case, People versus Tanae Tolliver.
Rachel McDuffie for the people.
I'm here. Here.
I like it when
Oh, there she is.
Attorney
All
McDuffie
right.
sticks it to him. It's fun.
Tolliver, you are before the court on a complaint that alleges that on or about August 2nd, 2022, at a location
Not that I'm
in
aware of.
MacArthur Boulevard in Superior Township,
Is Cone
that you
Killer
did
coming out?
committed the offense of assault and/or assault and battery upon a Shalisa Burnett. You understand the nature of that charge, man?
Yes.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes.
All right. This is the
Is
public
that
defender
seriously
case.
happening?
Thank you. Assistant Public Defender Melissa Kleeman on behalf of Ms. Tolliver, and she stands mute and waives the formal reading of the charges. We are asking for a PR bond and an adjournment of the pretrial.
Oh,
I didn't even wait formal reading. Standing mute. Court will enter a not guilty plea.
it's Janelle Day
Pretrial in this matter will be adjourned
all the way from Washtenaw County. It's Janelle.
February
Go
21st,
Killer!
2023,
Manigal.
8:30 before Judge Barr. Standard conditions, including no assault or
You
behavior,
can't be so lucky.
no alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Yes.
I am also going to order no contact with Shalisa Burnett. You understand that?
Yes.
Oh, I don't care what he
I'm
does.
also going to order that you do not go to
Judge Simpson will be Judge Simpson.
what's that address? 9312 MacArthur Boulevard. Do you understand that?
Yes.
Oh yeah, Rachel and I coordinated today.
Anything further from either side?
Okay, for the people.
No? All
No,
right.
Your
Thank
Honor.
you, ma'am.
If you ask her, she
Thank
has
you.
to deny it, but it happened. It happened.
Court calls the case of the people versus Joshua Cook.
Rachel McDuffie for the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Cook. Mr. Cook, if you could please unmute and state your name for the
I would
record.
love to. We'll see if we can get her in here.
Joshua Cook.
If anyone knows her,
Thank you.
give me a
Your
message.
Honor, in this matter,
Give me an
the
intro.
prosecutor has offered to dismiss this case if he resolves his felony matters. And I believe his felony cases have been adjourned out to February 23rd. So if we could get a date after that.
You have another date for Judge Brown?
Check his calendar. That's.
Oh, I need Janelle to come on here so I can pretend like I did this on purpose.
March 7th would be his next date.
And you can check with Judge Barr's chambers, but I'll set this for March 7th, 2023 at 8:30, and that's before Judge Barr.
Thank you.
And if something resolves before then, like I said, you can contact his chambers, see if you can get it moved out.
Absolutely. Thank
Right.
you so much.
Thank you.
Thank you, guys.
Thank you.
And
Have a good day.
Court calls the case of the people versus Rakesha Washington.
Rachel McDuffie for the people.
she is.
Yes, my name is Keisha Washington.
All right. Yep, I've seen her sitting there all morning. All right, ma'am.
Yep,
Yes.
there she is.
You are before the court on a complaint that alleges that on or about August 11th, 2022, location of 8814 MacArthur Boulevard, that you recklessly and or carelessly discharged a firearm causing damage to property over $50. Do you understand that?
I was actually just cleaning my
Hold on.
gun.
Hold on a second. I'm not asking whether or not you believe you did it. I'm asking, do you understand what you're charged with?
I love it.
What am I charged with, sir?
Let's do it this way.
We have a Canadian endorsement of
And you are before the court on a complaint that alleges that on or about August 11th, 2022,
Love
at
it.
the location of 8814 MacArthur Boulevard, Superior Township, Washington County, State of Michigan.
Oh
The
yes.
complaint alleges that on that date, you did, because of carelessness, recklessness, or negligence, but not willfully or wantingly, did cause or allow a pistol under your control to discharge, and that discharge, that it destroyed or injured property of Sycamore Metal, that the injury or damage to the property
Oh sweet
was a
Jesus.
value in excess of $50. Do you understand what you are charged with, ma'am?
Yes.
Shoot her purse or something? What's
That is a
going on
misdemeanor,
here?
punishable by up to 1 year incarceration and or a $500 fine plus court costs. Do you understand that, ma'am?
Yes.
Illinois in the
First
house.
question I have for you is, do you wish to be represented by an attorney?
Yes.
It's a public defender case.
Thank you. Assistant Public Defender Melissa Kleeman on behalf of Ms. Washington, and she stands mute and waives the formal reading of the charges. We're asking for a PR bond and an adjournment of the pretrial.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
What chest hair?
Pretrial in this matter will be adjourned February 21st, 2023, 8:30 before Judge Barr. The bond in this
I'm
case,
sorry, can you repeat that date again?
February 21st, 2023, 8:30. Judge Carl Barr.
Now, will that be in person or on Zoom?
You'll have to contact his chambers. My understanding is it will be via Zoom.
Okay.
Bond in this case will be set in an amount of $5,000. I will give a personal recognizance privilege on that. I will order standard conditions, including no assaultive behavior, no possession of alcohol, recreational marijuana, or any illegal drug. I will also indicate that the defendant is to not possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. Do you understand that, ma'am?
I'm sorry, Your Honor, I am a CPL holder.
Did you understand my bond condition?
Yes.
Thank you.
Your Honor, is the court in receipt of the bond recommendation form as well? We just have the two named individuals where the bullet went through their wall, so we wanted to request no contact with them.
Gotcha. I think it is somewhere buried.
I can spell it out if you need.
No, I think I got it. Yes, I do have it. No contact, ma'am, with Tabitha Meese. And Michael Wykovics. You understand that, ma'am?
Yes.
You want that spelling?
Don't give it to me, I will take it.
Okay. The Meese is Meese. Wow, Kovic is WYWLY. Okay, yeah, I see. Thank you, ma'am.
Thank you.
Donnell.
Court calls the case, People versus Mariah Donnell.
Rachel McDuffie for the people.
And good morning, Your Honor. Olga Yermolenko on behalf of Ms. Donnell was present via Zoom.
Good morning. Could you state your name, please?
Mariah Donnell, Your Honor.
All right, there she is. All right, what are we doing on these?
And Your Honor, as to the pre-trials, we do have a resolution as to both matters. And I do believe we need to address the bond violation we previously addressed 2 weeks ago. So I don't know what the court would like to start with.
Why don't we start with the bond violation? You're breaking up on me a little bit, Ms. Yermolenko, but
I'm sorry, Judge, I am in the building at 14A1 and the internet connection is a little slow, so I apologize.
okay, that's weird. Okay, all right.
That's weird.
Okay, there is a complaint of the bond violation. Well,
Darn it.
let me just check one thing.
I was hoping
have a couple of
Mariah was
these.
going to go kooky on us for fun, but she's represented by a very reasonable attorney here.
Okay, got it. All right.
And she's behaving herself anyway.
Well, why don't we do this? Because the bond violation, if there's a resolution, I think if she's admitting to the bond violation,
The things I need to know about
in
Mariah.
terms of any sentencing. But
He is
that might
admitted
be
to the
a while.
violations, Your Honor, to the bond violation.
All right. So what's the resolution?
All right, Ms. McDuffie, did you want to put that on the record or do you want me to?
Sure, no problem. I'm breaking up a little bit over here too myself. Let's see here. Okay, so the offer is for Ms. Donnell, and she has two cases. So in case 221-1384, Ms. Donnell can plead guilty to counts 1, 2, and 4 with the prosecutor's consent to HIDA, and I will dismiss count 3 in that matter, along with dismissing case number 221-1301 in its entirety.
And that is correct.
So she would plead guilty to counts 1, 2, and 4 in case 1384, with count 3 being dismissed, and the other matter would be dismissed in its entirety.
Correct.
Correct.
Oh, well.
And Ms.
welcome aboard.
Yarmolenko, is that what she wishes to do?
Yes, Your Honor.
All right. Mr. Nell, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
State your name for the record.
My name is Mariah Donnell, Your Honor.
Ma'am, it is this court's understanding you're going to plead guilty to 3 misdemeanors.
Yes, Your
I'm
Honor.
sorry. There was the. Did you say hideout?
Can't have this.
Prosecutor's consent to hide, Your Honor, yes.
Okay, thank you.
She's making
I just
sense.
wanna make sure
She's like
I'm
a
not
dream
wrong.
client in there.
All right. First of all, this court's understanding, ma'am, you're going to plead guilty to attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
It's also this court's understanding that you're going to plead guilty to the charge of assault and or assault and battery upon a Carmen Donnell. That is also a misdemeanor punishable by up to 93 days and a $500 fine plus court costs. You understand that?
Yes, Your Honor.
Also, this court's understanding you'll be pleading guilty to the stated count 4 of disturbing the peace. That's a misdemeanor punishable by up to 90 days and $500 fine plus court costs. You understand that, ma'am?
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty
Yes, Your Honor.
to the charge of attempted resisting and obstructing? How do you plead?
Guilty, Your Honor.
To the charge of assault and or assault and battery, how do you plead?
Guilty, Your Honor.
We don't get
To
fun,
the
Mariah.
charge of disturbing the peace, how do you plead?
Guilty, Your Honor.
We get reasonable and
Now,
appropriate,
you understand
Mariah.
that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
What kind of deal is this?
You understand that as a result of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Yeah, it's quite the
Are
fashion
you on
choice.
probation or parole?
I don't think so, Your Honor. I'm not exactly sure. I don't think so.
Okay.
I'm
All
sorry.
right. Okay. Back in September of last year, were you under the jurisdiction of any other court?
What exactly does that mean? Does that mean was I incarcerated?
Had you been sentenced?
It's a fair
Had you
question.
been sentenced and maybe required to report to probation by any other court?
No, Your Honor.
All right. You've not been to prison?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty to these charges?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
September 15th, 2022, at the location of 9302 MacArthur Boulevard, and also at the location of 5301 Macaulay Drive in Superior Township, Washtenaw County, State of Michigan. Did you come into contact with police officers, deputy sheriffs?
And I want to know what it is.
I believe so, Your Honor.
You believe so, or do you recall coming into contact with them?
If that was the day that I was, I think, taken to the hospital and then arrested, then yes, Your Honor.
And in being taken to the hospital and being arrested, in what way did you resist those officers if you think that you did, or attempt to resist them?
When they told me to get out the police car to go in the hospital, I told them that I didn't need to go in the hospital and I didn't want to, and they had to carry me out the car.
Okay, so when they told you to get out of the patrol vehicle, you didn't get out of the patrol vehicle or follow their instructions. Is that correct?
Yes, Your Honor.
And they were in the lawful performance of their duties when they were asking you to do that. Is that correct?
Yes, Your Honor.
All right. On that same date, and I guess at the location of the MacArthur Boulevard address,
Thank you,
what
Sherry.
did you do regarding a Carmen Donnell that makes you think that you're guilty?
I believe me and her were arguing and I pushed her. So
Who is she to you?
she's my mother, Your Honor.
Okay, so you pushed your mom?
Yeah.
How old are you?
I'm 22, Your Honor.
Oh, here it comes.
You're not old enough to do that, but you pushed your mom, right?
I'm never old enough to do that, Your Honor.
Good answer.
I know. That's why I'm asking, but you did that. You did it on purpose?
Yeah, Your Honor.
And you didn't have your mother's permission to push her, did you?
No, Your Honor.
Okay, going back to the hospital, when they got you to the hospital and they were taking you out of the vehicle, how'd you disturb the peace and repose of the area around the hospital when they were trying to get you out? Were you screaming? What were you doing?
I had asked, one of the nurses asked them to cover me up with a sheet. And then I repeated that and asked that, and I got louder when I asked, and then they ignored my request. So I got out of the wheelchair that they had put me in and I just stood up, and then they had to carry me the rest of the way.
So in that respect, you disturbed the peace and repose of the area immediately surrounding you by your actions. Is that correct?
Yes, Your Honor.
Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's case?
Yes, Your Honor.
Yes, Your Honor, people are satisfied.
Court will accept the defendant's pleas of guilty to counts 1, 2, and 4 in case 1384. Count 3 in that case is dismissed, as well as the case of 22-1301 is also dismissed pursuant to the plea agreement. Defendant is referred to probation for a pre-sentence investigation and report.
She sidestepped a huge lecture there by answering properly.
Sentencing on this and the violation will be set for. Is she in custody? She's in custody, obviously. Is this the only thing holding her at this point?
I believe so, Your Honor.
All right, so what's my early date? February.
February 8th.
Sentencing will be set for February 8th, 2023, 9 a.m.
Yeah.
Right?
Yesenia just texted me
Judge,
with
may we address the
ma'am.
bond?
stuff I need to
You may
do.
go ahead.
I'm going to get
Mayor,
right
I
talking
would
to you
ask
later.
the court to consider releasing Ms. John Allen a personal bond. However, we would request that the court add a condition of a scram tether. Her previous violations all had to do with sober-link device. I think in order to avoid her not testing in a timely manner, I think the scram tether would be an appropriate alternative. Is the court able to hear me? I'm sorry.
Yes, I was able to hear you. Any response from the people?
Your Honor, the people would agree that a scram tether would be appropriate, given that a sober link is obviously something that Ms. Donnell was not able to handle. But we also have the matter of the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, something like 15 missed drug tests. And the one that she did take was positive for THC. So we still are going to have a testing issue with substances.
Exactly.
Beyond
And I'm
alcohol.
not happy about it.
Yes.
And Judge, Ms. Donnell does have she was previously living or staying with her father, who lived a little bit further away from this area. She now has a relative, her uncle, who resides on Frederick Street in Ypsilanti, who she's able to reside with. I spoke to Mr. Ford, her uncle, and he verified
Good Lord.
that
We had,
You're going out. I'm sorry.
we just witnessed a defendant do an
I
excellent
got
job
Frederick, and then
with an ugly
I didn't get
situation.
anything else after that, Miss Yermely.
She has an uncle who lives at that address.
This does not belong in Law Talk with Mike.
I spoke to Mr. Ford, and he verified the fact that she's able to stay with him. So she would be nearby, which would help her with, testing and community corrections.
Does she work? I mean, what do you do during the day?
I work at the Union Rec, Your Honor. I mean, I don't know for sure if I still have my job now because I've been incarcerated for the past 2 weeks. But I do have a interview set up for, I believe, the 26th or the 27th of this month at E.B. Brown. So I am going to be getting a job. It has an immediate start date. I just have to make it to the interview. And then I do have a legal and up-to-date medical marijuana card. And I can bring all my documents
Is it
and
lawful?
plus the actual card to community corrections to show them. And,
Stop
I can
the
test
marijuana.
twice a week if y'all need be.
It's not working for you. It's time for a new start. You're doing well. You're taking instructions. You're being respectful. You're busting out of the clink. Good work. Leave the marijuana alone. I'll give you the lecture that Judge Simpson wants to give you, but it's too busy too right now.
All right. If I let you out, what's going on with you? Because you got this, you then had the violation, you got all those missed tests, you can't follow the instructions on the sober link.
Yes, Your Honor.
Tell me why I should believe that you're going to do anything I ask you to do.
Because the main part with the sober link, it wasn't me, not wanting to blow. It was the time I worked. I worked from 2 p.m. to about 1 in the morning. And I was a line cook. So I never had, I would forget, time would get past me. And then the time I did test positive, that was all my fault. I willingly consumed alcohol, wasn't thinking about the consequences only because I had a bad day.
Oh, sweet Jesus.
Like Mrs. Amaneka said, that I do have somewhere I can stay now that's close, right in the middle of Ipsy, where I'll be able to have reliable transportation to community corrections. As many times as you want me to test per week, I can do it. It was just mostly that I was like over an hour away. So that was the hardest
You didn't want to comply and you wanted to drink is what it was.
I'm gonna be in Ipsy, so I'll be able to comply with all the court's orders and you won't have to worry about me missing one single drop or at all or anything.
Your Honor, may the people just inquire, Ms. Donnell mentioned that she has a valid medical marijuana card. When was that issued to you?
That was issued,
I had this question.
I want to say August of 2022 or 21. I think it expires this August coming up.
So our concern is just compliance, because that card would have been issued to her and available to be provided to community corrections before she ever started testing on this case. So there wouldn't have been an issue with,
Right.
So my concern is she was previously
Is that she's
required
lying.
to test twice a week, as she just volunteered to do.
I'll
So
say it.
that's the people's struggle.
I'm sorry, Mrs. McDuffie. My understanding was I was only supposed to test once a week, even though I wasn't doing that either.
Yeah,
But,
I think that's what she really
I
meant.
could say that now the issue was just I was very far. Now if I need to, I'll get on the bus. I will walk there. I'll make sure I get there. I will not let y'all down. If y'all are able to give me one more chance. And then the scram tether, I would rather have that because then I won't have to forget to blow, and then I'm always monitored. So I could just ask y'all, give me one more chance. I won't let y'all down at all.
Young lady, I don't know what's going on with you, but it just seems to me that what you do is you kind of decide you're just going to do stuff your way.
No, Your Honor. It's just things were out of my hands after what happened with my mom. I wasn't able to stay with her, so I had to stay with my dad.
Yeah, because you kind of forfeit that right when you hit your mama.
You're right, Your Honor.
Oh, I know I'm right.
I'm not confused on the issue.
But that's what I'm saying. You just do what you want to do. and then you don't do, and you're just gonna blame it on being out of your hands. Quite frankly, if you just do the right thing, you wouldn't have any problems. But everything you seem to do is just wrong.
Yep, you're right, Your Honor. I'm getting on the right track now. If y'all would give me one more chance, if y'all would give me a chance at a scram.
Okay, and let me just tell you this. Let me just tell you this. And that is, and Miss Yermolenko will tell you, you can ask me for one more chance, but you better make it good.
I swear I will, Your Honor. I promise.
No, yeah, okay. Because I have, I think what, 365 days or 365 reasons why you should make it good. And again, if you don't believe me, ask your attorney. I will use that. I don't have a problem doing it if you don't do what I tell you to do.
Yes, Your Honor, I hear you.
Houghton Lake in the
And I
house.
don't accept a whole lot of excuses.
Yes, Your Honor. I know.
What is that address on Frederick, Ms. Yermolenko?
928 Frederick Street, Unit 1.
That's not subsidized, is it?
I don't believe so, Your Honor. I asked Ms. Donnell.
Okay.
Good morning, Mag.
Just to make sure that there's no problem with his. So here's what I'm gonna do so that we can see if you can follow instructions for any given period in time.
Yeah, I
I'm
agree.
actually gonna set her sentencing out
Ms. Reed has potential.
to March 1st,
I mean, we'll see, but
2023.
I see potential.
I'm going to release the defendant on a personal recognizance bond. Previous conditions, personal recognizance, $10,000 bond with their previous conditions, but I'm going to add some other conditions. So I'm signing a new order regarding drug testing. She is to test 2 times per week. Okay.
All right.
That's at community
When is
correction.
Janelle on the call?
I'm then going to place you on a scram tether unit. I've signed that order. You must, and I'm going to indicate on here that I want that scram on prior to your release. I'm also going to order, at least for the time being, that you're also going to be placed on a GPS tether for home confinement to that address, to the 928 Frederick, Unit 1 in Ipsy. You can only leave the only exceptions would be work. We will allow you to leave for the work interview you talked about and for drug testing. You understand that, young lady?
Yes, Your Honor.
And let's see, you're telling me you can do this. Let's see if you can make it to March 1st with these conditions. Anything further, Ms. Yermolenko?
No, Your Honor. So Ms. Donnell will just contact probation once she's released. Is that right?
Actually, what we're going to do is we're going to put her into a room right now with probation. They'll get the information.
Okay, that's what I wanted to make sure.
Okay, Ms. Tang, if you could do that for us, something happened with the physical computer here in this courtroom.
Do we ever see
Yes,
Ms.
Judge,
Tang?
that's for probation intake and Ms.
She
Donnell,
behind the
correct?
scenes.
Yes, it is. Thank you.
Thank you, Your Honor.
All right, thank you. Court does call the case of the people versus Emily Gordon.
Rachel McDuffie for the people.
Ms. Gordon?
Good morning, Your Honor. This is Emily Gordon.
All right. And you're here on an arraignment. I guess you don't have counsel on this yet. Ma'am, you are before the court on the charge that alleges that on or about July 30th, 2022, at the location of 5301 Macaulay Drive, Superior Township, that being the hospital, that you did commit an assault and battery upon a Kristen Keaton. Do you understand the nature of those charges, ma'am?
I'm sorry, I don't recall this.
Okay, but do you understand what you're charged with?
No, I don't.
Oh, good God. Here we go.
Ma'am, you are before the court on a complaint that alleges that on or about July 30th, 2022, at the location of 5301 Macaulay Drive, Superior Township, Washtenaw County, State of Michigan. The complaint alleges that you did make an assault and or an assault and battery upon the following person.
We need
That
David to
being a
shorten this
Kristen Keaton,
procedure.
contrary to Michigan statutes. Ma'am, do you understand the charges against you?
I understand what you're saying. I don't understand because this has never perspired. I don't know if somebody else used my name.
Ma'am, I'm not asking you whether or not you did it or not. Do you understand what you are being charged with?
I don't know a Kristen Key.
Do you understand whether you know this person or not? Do you understand what you are being charged with?
I don't understand why you are trying to charge me with
I'm
that.
not, that's not my question to you.
That's not the question.
Do you understand what you are charged with?
Okay, yeah, sure.
Thank you. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that, ma'am?
Yes.
First question I have for you is, do you wish to be represented by an attorney?
Yes, I do, because I don't recall this altercation.
This is a public defender case.
Yes is good.
Thank you, Assistant Public Defender Melissa Kleeman, on behalf of Ms. Gordon. She waives the formal reading and stands mute, and we are asking for an adjournment of the pretrial. As to bond, she is being held without bond on a felony matter, so we are asking the court to set a nominal bond in this case so that she
Thank
gets
you,
jail credit.
Melissa.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial in this matter will be adjourned February 21st, 2023.
At 10:30, please.
These are all set at 10:30.
Yes, please.
Seriously? All right, fine. 10:30 a.m. Start. Well, never mind. That's not interesting. Bond in this case will be set in the amount of $1,000. I'll give a 10% privilege on that. It's a condition of her release. I'll order standard conditions, including no assaultive behavior. There's to be no use of alcohol, recreational marijuana, or any illegal drugs. I'm also going to indicate, ma'am, that you are to have no contact, which shouldn't be an issue since you say you don't know, with Kristen Keaton. You understand that?
Yes, how do you spell her last name? Yes, I understand.
Keaton.
Keaton, Kristen Keaton. I've never heard of this one.
Okay, ma'am.
Your Honor,
Why do you think it's funny?
Ma'am.
Ms.
Yes,
Keaton-
Ms.
Ms.
McDuffie.
Keaton is a nurse at the hospital, so it's understandable that she might not have a relationship with her on a personal level beyond this incident. Given that, the people are also going to make the same request that is commonly given in these cases, which is no going to the hospital except for emergency care.
Yes, that's what I'm going to do. So, ma'am, you are
And of
also
course-
not to go
To Fulton County.
to St. Joe's Mercy Hospital.
Oh, yeah, there too.
Except for emergencies. You understand that?
Yes.
Yeah, Lolo, that's the fee schedule. Uh-huh.
Thank you. Yes, ma'am.
So this, I don't understand. Can I have a breakout room?
No.
We don't have any more information about the case quite yet anyway, ma'am. As soon as we get discovery, someone from my office will be up to talk with you.
Thank you.
Thank you, Ms. Cleveland. All right. Court calls the case. People versus Zakalia. What's that?
Rachel McDuffie for the people.
Not checked in. Are both cases?
No, just 1970.
What's that? No response. Bench warrant will issue for defendant's failure to appear.
Bench warrant.
Bond will be set in the amount of 5,000. 10%. That warrant will issue immediately. Court calls the case of the people versus Tavon Johnson.
Rachel McDuffie for the people.
Sir, is that right?
Good morning, Your Honor. John Vincent on behalf of Tavon Johnson.
Mr. Tavon Johnson, I'm sorry.
All right. Okay, what are we doing?
Your Honor, at this point, there is a HIDA offer on the table from the prosecutor. I've discussed that with Mr. Johnson and all the ramifications thereof. However, set this for a final settlement contract.
Do you have a final settlement conference? Jury selection will be the same day.
Yes, February 8th.
Final settlement conference will be February 8th, 2023 at what time?
1:30 p.m.
At 1:30 with jury selection February 13th, 2023 at
8:30.
At 8:30. And both of those proceedings are before Judge Barr. You need to check with the court to determine if they are in person.
Yeah, you might have a problem.
Jury selection obviously is, but as to how to handle the final settlement conference.
There are treatments for Judge
Thank
Simpson
you.
eviction.
Thank you, Your Honor.
Yeah. Court calls the case. People versus Alfred Jackson.
Rachel McDuffie for the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Jackson. Mr. Jackson, could you please state your name for the record?
Alfred Jackson.
Alfred Jackson. Oh, there he is.
Thank you, Your Honor. Mr. Jackson is planning on pleading guilty as charged to this matter today.
Is that correct, Mr. Jackson?
Yes, sir.
All right, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again.
Alfred Jackson.
All right, you can put your hand down.
I need
Sir,
to
it's the
clip.
court's understanding you're going to plead guilty to the charge of trespass. That
need to
is a
clip Judge
misdemeanor. It is punishable
Same
by
story, Mr.
up
Jackson.
to 30 days in jail, $250 fine plus court costs. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
And to that charge,
Yes.
how do you plead?
I plead guilty to it because I shouldn't have been there, which I was dropping off my kids, but that's not nobody's problem but mine. But I ain't, that's either in the past.
Okay, I just
Shouldn't have
asked
been
you. All right. I just asked you how you pled. So guilty?
Yes.
Yeah, all right. Now you understand that by pleading guilty, that you'll not have a trial of any kind.
I
Mr.
believe he stated
Jackson,
something and it just.
Yes.
you understand that you
Yes.
won't have a trial.
Yes.
Okay.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything
Nothing.
to get you to plead to this charge?
No.
Sometimes
Anybody
it
threaten
happens.
you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and because you believe that you're guilty?
Yes.
March 16, 2022, at the location of 9446 MacArthur Boulevard, Superior Township, Washington County, State of Michigan. Did you go onto those premises of Sycamore Meadows and Danbury Park?
No, I was at what's that? 8634 MacArthur Boulevard. I don't know about that address. You'll see.
All right, but you were in Sycamore Meadows and Danbury Park, right?
No, I was in Sycamore Meadows.
Okay. You were in Sycamore Meadows.
Yes, that's
right?
where I got arrested at, in Sycamore Meadows.
All right. Had you been told that you weren't permitted to be on Sycamore Meadows property by Deputy Gambos
Yes.
previously?
Yeah, but I had thought the reason why I came on the property, I had to trespass and I thought it was over with. I came on the property because they know me, so he hopped out and grabbed me, and that's when I.
Okay. You had previously been told not to be on the property, right?
Yes.
And you were on the property.
Yes.
All right. And you were mistaken as to whether or not that trespassing notice had expired. Is that correct?
Yes, I had called the rent office and everything, and they alleged it was over with, but by the police eyes, it wasn't over with. And then my lawyer told me what day, because I was telling her, I'm like, I wasn't on the trespassing list the day that I dropped my kids off. And that's when they seen me.
All right, let me ask you this. With everything you know now, were you trespassing on the property that day?
Basically, yeah, you can say that. Yeah, I was.
Well, basically, were you trespassing on the property that day?
That's what we're trying to say.
Yes, I was.
Okay. And you want to plead guilty to this charge. Is that correct?
Yes, sir.
Counsel, if I complied with the court rule, would it be proper to accept this defendant's plea?
People were satisfied a half hour ago, Your Honor.
Defense is satisfied as well.
Is defense satisfied?
Yes, Your Honor.
All right, that's it. She's got to come on.
Court will
I'll
accept
talk
the
to Mike.
defendant's plea of guilty to this charge, finally. Young man, I would normally just send you. What brings you out that way?
All right, yeah, Honor, I'm gonna just be real sweet with you, right? So I was dropping my, I was dropping my kids off. So in order for the police to get called, I was dropping my kid off to my baby mother's house. So I got a baby mama that's just loud, and she just completely loud. So I'm dropping the kids off, and then I was
Your
telling
Honor,
you that's how
I do believe
got
that
on
his
the
children
property.
live at Sycamore Meadows. And so that is the reason he would have to visit the property.
Thank you for simplifying that, Ms. Reed. Okay, so that we can get a full picture of this, I'm going to refer the defendant to probation for PSI and maybe some recommendations as to how we can keep him from doing this. Sentencing will be March 1st, 2023, 9 a.m.
Call long enough.
All right, young man, what I'm going to do is I'm going to put you into a breakout room with my probation department so they can get some information.
Okay.
Okay, so when they ask you a question, just answer their question.
All right.
All right.
Yeah.
Let me try to give them all that information. All right. Thank you.
All right. Yep.
Court calls the case. People versus Deion Bird. Are all three of them?
Yes, sir.
Rachel McDuffie for the people on the state matter.
Bill Williams for Superior Township.
Deion Bird.
Deion Bird here.
There he is. All right. What are we doing on these?
Your Honor,
these
our office was
are they all
appointed
arraignments?
on one of these matters.
Hold on 1 second. I think they're.
I believe 1972 is an arraignment. David Goldstein is on one of these cases.
Okay, so hold on.
He was
one
going to be on
moment.
all three.
Pardon?
I believe he was going to be on all three matters.
I think he was too. Well, let me arraign you on this charge, Mr. Bird. I understand. Mr. Goldstein represents you on these, Mr. Bird?
Yes.
Okay.
Well, which ones are you talking about? They're flooding in by the bookload, so you got to,
You just
gotta
picking
figure
up
out
a boatload of
which
these
charges.
things. Okay, you got a no insurance under the insurance code.
Okay.
Okay. And then you have an attempted resisting and obstructing a police officer.
Yeah, he's my lawyer for that one. The insurance thing, we can deal with that or try to have a resolution for it.
Your Honor, I recall at our last hearing that once you arraigned Mr. Bird on the township charge, Mr. Goldstein did assign himself.
Say that he was going to represent you on the insurance.
Yeah.
Okay.
So trespass, I think that's the one he needs to be arraigned on today.
Well, and so that takes care of those two. Then, Mr. Bird, you have another charge of trespass. Okay.
Well, may I ask what money here is that?
Hold up. I don't know why everybody wants to talk to me about the trespassing case.
Sounds like something illegal going on to me.
Huh?
Sounds like illegal. That's a private property.
Well, yeah, okay.
Yeah, private.
Go ahead with that. Yeah, go ahead with that, but you're gonna have a problem. So here's what we're gonna do. I used to handle this docket all the time. So you want to run that defense, you go right ahead. That we'll see how that works for you. But I'm going to arraign you on this charge. Just hold on. Hold on. I don't want Mr. Bird. I don't want you saying anything about the charges, okay? Understand that? Let's just try to get through this arraignment. The complaint alleges that on or about April 2nd, 2022, at the location of Sycamore Meadows, Danbury Park Manor, that you were trespassing on those premises after having been forbidden to do so by Deputy Barabbas. Do you understand the nature of that charge, sir?
Yes.
That is a misdemeanor punishable by up to 30 days and or a $250 fine plus court costs. You understand that?
Mm-hmm.
Yes?
Yes.
Okay. Is Mr. Goldstein going to represent you on this, or do you need me to appoint the public defender on it?
Goldstein.
You think he's going to represent you on it?
Mm-hmm.
Okay. Then what I'm going to do is I'm going to indicate that you're standing mute to this charge, enter a not guilty plea on your behalf. I'm not going to make it a public defender case because I think Mr. Goldstein was going to take your other two matters too. I'm going to adjourn all of these to February 21st, 2023 at 10:30. And those are all now before Judge Barr. His bond in this case, I will set at.
Was there a Janelle sighting?
A personal recognizance $5,000 bond.
I don't see her.
Standard conditions, including no assault behavior, no alcohol, recreational marijuana, or illegal drugs. I'll indicate that he is not to enter Sycamore Meadows or Danbury Green. Thank you. Court calls the case, People versus Cheryl Lynch.
Sylvana Reed, Assistant Public Defender, with and on behalf of Ms. Lynch. Ms. Lynch, could you please unmute and state your name for the record?
Cheryl Lynch.
I have Mr. Williams for this case, Your Honor.
This is a Superior Township case. Yeah.
No Williams for Superior Township.
Your Honor, Ms. Lynch informs me that she just owes, I believe, $276 to the 14B court. And she's been informed that she can get her license after that. And so we would just ask for an adjournment so that she can get that taken care of.
So she just
How much
popped on
time
for a
we gonna
second.
need to do that, ma'am?
They're giving me till March the 20th.
March?
Yes.
Okay, here's what I'll do. I understand that, but as far as I'm gonna go is March 7th.
Yes.
2023 at 10:30. That's before Judge Barr, okay?
Okay.
And at that point, if you need a little bit more time, you'll have to ask him.
Okay. Thank you.
You're welcome, ma'am.
All right.
Court calls the case, People versus Wayne Minor.
Rachel McDuffie for the people.
Sylvana Reed, Assistant Public Defender, with and on behalf of Mr. Minor. Mr. Minor, could you please unmute and state your name for the record?
Wayne Minor.
Your Honor, we were given an offer by the prosecutor yesterday, and Mr. Minor would just like an adjournment so that he can consider that.
Adjourn the matter to February 14th, 2022, 23, 9 a.m.
I'm sorry, I missed that. Can you say that again, Your Honor?
February 14th, 9 a.m.
Okay, thank you.
Thank you, sir. Court calls the case, People versus AJ Stovall.
Sylvana Reed, Assistant Public Defender, with and on behalf of Mr. Stovall. Mr. Stovall, if you're present, could you please unmute and state your name for the record?
AJ Stovall.
Thank you.
Hey, what are we doing?
Your Honor, Mr. Stovall is planning to plead to OWI second. That was the offer in this matter, as opposed to the high BAC count.
For 1 year.
Good morning.
that-
Thank you.
Okay.
No, she hasn't been called yet.
Okay, I got an interpreter.
I haven't seen her, but Chad's telling me she's popped on a couple times.
Hold on, Mr. Stovall. We have an interpreter present. Let's get that one then.
Okay.
Okay.
Good afternoon, Madam Interpreter. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. We need your assistance with one criminal matter. Can you please raise your right hand to be sworn, Miss Emily?
I'll be glad to assist. Before I proceed, do you mind providing the 4-digit access code?
Sure, it's 1423.
Thank you so much. You may proceed.
Thank you. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court, so help you God?
I do.
Thank you.
Good morning, Madam Interpreter.
Good morning, Your Honor.
Court does call the case of the State of Michigan versus Luis Aponte.
El tribunal llama la causa del estado de Michigan versus el señor Luis Aponte.
Rachel McDuffie for the people.
Rachel McDuffie de parte del pueblo.
John Vincent on behalf of the defendant, Luis Aponte.
John Vincent de parte del acusado, el señor Luis Aponte.
Your Honor, in this case, Mr. Aponte has some felony charges on him.
Su señoría, ante esta causa, el señor Aponte tiene algunas acusaciones por delito mayor.
I have spoken with the attorney, Michael Gaddy, who is representing him on those felonies.
Yo he hablado con el abogado Michael Gary, que lo está representando ante estos delitos mayores.
He informs me there's a preliminary exam scheduled for February 7th.
Él me ha informado que hay una audiencia preliminar establecida para el 7 de febrero.
So we would ask for an adjournment to sometime after that, presuming that he is bound over. We are going to try to find a galactic solution to all of this.
Entonces estoy solicitando un aplazamiento para alguna fecha posterior a esa,
I'm not getting that.
presumiendo que va
I
a
got my
ser
license
liberado
fine.
bajo fianza para hallar alguna solución galáctica a todo esto.
I believe he is earning time on the misdemeanor charge I am representing him on. I believe he's already been in for 55 days at this point.
Me parece que ya él ha servido el tiempo por el delito menor por el cual lo estoy representando en esta causa. Me parece que ya ha servido 55 días en cárcel.
Without objection, I will adjourn the matter to February 21st, 2022, 10:30, before Judge Barr.
Your Honor, did you mean 2023?
Yes, 2023. Thank you, Madam Interpreter.
Thank you, Your Honor. Muy bien, entonces sin ninguna objeción voy a aplazar la causa para el 21 de febrero del 2023 a las 10:30 de la mañana.
¿El 20 qué?
So, Your Honor, just to repeat for me, it's February 21st at 10:30, excuse me, in front of Judge Barr. Do we know if that's a Zoom or in person?
I do not know.
All right, thank you, Your Honor.
About pre-trial.
Juicio preliminar.
Thank you.
Thank you, Your Honor.
Thank you, Madam Interpreter.
My pleasure. Thank you for using our services as well. Bye-bye.
Where are you going back to? Okay, now I'm running to home.
All right, court recalls the case of the people versus AJ Stovall.
Rachel McDuffie for the people.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Stovall. Mr. Stovall, could you please state your name for the record?
AJ Stovall.
Thank you.
And he's going to plead to impaired second.
Yes, that is correct.
For 1 year. And then that's an added count 3. And then 1 and 2 would be dismissed. Is that what we're doing?
Is that correct, Ms. McDuffie?
1 second, I just want to pull up the charging document. Make sure. Yes, I will go ahead and dismiss the opening ties. Count 2.
So 1 and 2. Okay. Mr. Stovall, can you raise your right hand?
Hey, excuse me, Your Honor, can I ask one question? I mean, can I throw this in there? I'm having a custody meeting for my daughter. Like, I mean, I'm going through the course her. Is it possible, can I get this pushed back for another 2 weeks while I handle that? I'm just not trying to get like no jail time or nothing like that. And I'm trying to go through this custody.
Okay, so you don't want to plead today. All right.
I'm going to plead for sure, but I'm just trying to take care of this real quick. Is it possible?
Okay, that's fine. This is our second go around on this. So here's what I'm going to do. No, that's okay. I understand. So I'm going to adjourn this matter out February 21st, 2023, 10:30. That's before Judge Barr.
That actually made sense.
Okay, so this is now the messiest
Do you want to give it to me and I'll make it pretty?
Well, I don't know if you can do much, but here. All right.
All right, ready until the taper.
Court calls the case, People versus Tova Taylor.
Rachel McDuffie for the people.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Taylor. Ms. Taylor, could you please unmute and state your name for the record?
Tova Taylor.
Thank
It
you.
actually did.
Your Honor, in this matter, we would like to schedule a jury final settlement conference.
Final settlement conference, February 8th, 2023 at 1:30. Jury selection, February 10th, or February 13th, 2023 at,
I don't know,
8:30.
Thank you.
We've got some good potential
And Your Honor,
coming up here.
Is Ms. Taylor still present?
And those, I should say, those proceedings are before Judge Barr.
Correct, Your Honor. I just wanted to confirm for the record, Ms. Taylor, as I understand it, is rejecting, so I want to make sure that that's clear. So it will be off the table after today's hearing. There was an offer from
I didn't offer presented to me at all.
Okay, so let me place that offer on the record, and it can remain open through the end of the final settlement conference. The offer from the people was for Ms. Taylor to either plead guilty as charged with the prosecutor's deferred, so that's a dismissal of that charge following successful completion of probation, or option 2 was to plead to a reduced count of disorderly jostling, but with no dismissal attached. So those were the two options that we made available to Ms. Taylor. So since she's representing to the court now that she had never heard of those offers, then I will leave them open through the end of the final settlement conference that was just said.
Thank you.
Thank you.
Court calls the case, Zeisler. People versus Jennifer Zeisler.
Yeah, I've never heard of
Rachel
that
McDuffie for the
charge.
people.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Zeisler. Ms. Zeisler, could you please state your name for the record?
Jennifer Denise Zeisler.
Thank you. Your Honor, in this matter, Ms. Zeisler is planning to plead no contest as charged.
I think I've seen her before.
Ms. Zeisler, can you please raise your right hand? Thank you. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Praise to God.
Okay. State your name again for the record, Ms. Zeisler. Can you say your name?
Jennifer Denise Zeisler.
All right. You can put your hand down. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. Is that correct?
Yes, I correct.
All right.
I correct.
As I've said, that's a misdemeanor punishable by up to 93 days in jail and a $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right.
It's a perfect.
Do you understand what a no contest plea is?
It really is. Yes, I correct.
No, Your Honor.
Okay, let me explain a couple things about it. No contest plea means that you don't want to contest or fight this charge anymore. You understand that?
Yes, Your Honor.
Right. The second thing that you need to understand about it is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Okay. Do you have any other questions regarding a no contest plea, Ms. Zeisler?
No.
All right. Ms. Reed, the basis for the no contest plea?
Potential civil liability.
All right. So, Ms. Zeisler?
Yes, Your Honor.
How do you plead to the charge of assault and or assault and battery?
Guilty.
You mean no contest?
Yes.
All right. So you're pleading no contest. Is that correct?
Yes.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
Because you're not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you or to have this court compel their attendance. You're giving up your right to see and hear and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything to get you to plead no contest?
I just see it as an
No, Your
accident.
Honor.
Has anybody threatened you or coerced you in any
No,
way?
Your Honor. No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report for their case number 2274463 and has reviewed saying, counsel, any objection to the court reviewing that report?
No objection from the defense.
None from the people, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's no contest plea to this case. Defendants referred to probation for a pre-sentence investigation and report and determination of any restitution. Sentencing in this matter will be March 1st, 2023, 9 a.m.
Thank you.
Thank you. Okay, Ms. Geisler?
Yes.
Geisler, I need you to hang on. We're going to put you into a breakout room with my probation department so you can speak with them, okay?
Mm-hmm.
You just stay where you are and we'll move you, okay? Thank you.
Uh-huh.
It's the end of 10. Oh, okay. We're not too bad. All right, court's going to stand in brief recess. We run through 2 blocks now. And we've got to get a computer back up. So it may take us a minute, but court's going to stand in recess, folks. Thank you.
Well, I wasn't prepared for this recess here. 20-minute break. We might just we might just pause or something. I mean, otherwise, I'm just gonna harass you with my clips. We can't have that. How do you know these things, Biggin? You're flopping around down there in Georgia. How do you know there's going to be a break in Washtenaw County? Inquiring minds want to know. Biggin knows all. All right. I guess we'll just leave that there and take a break. I'd turn it off, but I think it's going to be a short break. Now I'm invested in this. Maybe if I'm really lucky, I can make my call. That would be a good play. But I'm not going anywhere. I'm just going to listen. When I hear him again, I'll be back.
can't see you now, so if you have your right hand raised, please let me know when you have it raised.
Yes, it's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I suppose.
I need a yes or a no.
Excuse me, can I ask a question?
No, put place your screen on mute.
He was dry humping all that, dude.
Oh my God!
Yeah, that's what I was saying. He was getting after it when I pulled up.
Oh, look at your attitude, like I did you something. Girl, I haven't done you anything, I promise you.
25,000.
That's so dumb.
I know, it's ridiculous, isn't it? It's stupid.
Yeah, copy is $2,500. Yeah, you're going
Here,
down.
no, ma'am, you're right. It is crazy. Let's change that. Bond's 50,000.
Will stay out of Fulton County, sir. The only reason you're going to come to Fulton County is court or to see your lawyer. Not even get gas. Can't even stop at Chick-fil-A. Stay away.
Ma'am, you didn't say the cat jumped on his wiener, did you?
Oh my gosh, it is a double rainbow. I cannot believe it. It's a freaking double rainbow.
And great morning. All right.
Okay.
I am Judge Lanice Bryant. Welcome to the 36th District Court. You are at the 36th District Court. You are at 36th District Court. You are at 36th District Court.
Where are we, Judge?
You are at 36th District Court. You have law.
Please state your name for the record, ma'am.
These nuts.
Okay, thank you.
That means you.
He's a lumberjack and he's okay. He sleeps all night and he works all day.
Annie is asking very nicely for you to like, subscribe, and hit the bell notification. And if you ignore Annie, you do realize that that is considered capital felony treason.
Have you ever had a failure to appear?
Possibly.
No, you may not.
What is this, recess?
The wheels of justice are going to roll you right into the Wayne County Jail.
time was, okay, we gotta leave at 8 o'clock. If I wasn't out by the car by 7:50.
They're gone. Exactly. My dad used to make fun of how he would come in. When I'd come in at night, if I was like running late, he'd hear me like, come in sideways into the driveway.
All right, tell me when they
All
start.
right,
again.
now we got Miss Sullivan here. All right, so we're going to step aside from this. When I get an officer here, though, Miss Letton and Miss Hood, I'm going to pause it because these criminal cases come before them, but I'm trying to multitask here. Miss Sullivan, Mr. Sullivan, raise your right hand, please. Do y'all swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Mr. Sullivan?
I do, Your Honor.
Miss Sullivan?
Yes, I do, Your Honor.
All right. Who's starting out? Ms. Letton, or is it Ms. Hood? You're trying to modify something.
Yes, Your Honor, this is just a motion to modify and amend or set aside the final order. As you can recall, we were before the court on September 30th, 2022 for a final hearing. This motion is based upon the order that Your Honor had signed in reference to this matter. The petitioner in this case takes exception in reference to the order that was drafted by Attorney Lutton, who represents Mr. Sullivan in this matter, Your Honor. This motion to modify and amend or set aside is specifically in reference to the paragraph that's outlined in the final order, paragraph 1. As the court may recall that there was a number of witnesses and evidence that was brought forth. One of the things that the petitioner takes exception to is that there was no mention in reference to the May 6th date. As Your Honor can recall, there was a partial hearing that took place on May 6th. And of course, the court may recall there was a lot of resets in reference to finalizing that hearing.
Good Lord.
In which that final hearing didn't take place until September 30th.
Is this the case I streamed?
So in reference to the May 6th, there was information, exhibits, testimony that was not mentioned in Your Honor's final order in reference to this matter. But specifically, what we take exception to, Your Honor, is that in paragraph 1 in the order, it says as such, the court finds that after the hearing, the evidence and argument of counsel, there's no immediate risk of harm to the petitioner. We don't specifically take exception to that because
you take exception to
in the
losing.
court's ruling on September 30th,
Most
the
people do.
court did indicate that there was no significant risk of harm in reference to the petitioner. What we take exception to, Your Honor, is that in the order in paragraph 1, it stated that furthermore, the court finds the petitioner did not provide sufficient evidence to support her claims of physical violence by respondent. If the court can look at the transcript that was provided on September 30th or what was taken down, the court did not say that the evidence was unsupported. What the court indicated in its ruling is that on page 5 of the transcript that's attached as exhibit A, line 4, the court said the burden here is the preponderance of the evidence, more likely than not, which is a higher burden. You have probable cause.
Sure did.
So I didn't see a whole bunch of proof of anything with the bruising on the neck. She shows us a bruise on her leg, no bruising of the neck. If she were choked, it would use the broomstick to choke her, that there was none of that. I mean, I didn't see but one picture of the bruise on the leg. As Your Honor may recall, the petitioner didn't necessarily just allege that she was choked. She also alleged that she was hit with the broomstick too. So in reference to the petitioner saying that there was not provide sufficient evidence, that's not what the court's ruling was. In addition to that, the petitioner—
This is a motion to reconsider or something?
Excuse me, the respondent indicated that although petitioner claimed the respondent choked her with broom, she failed to provide any evidence of the same. But as Your Honor, we can recall there was evidence from the officer who also indicated that he saw some bruising on her leg and also indicated that he was the one who took the picture. In addition, in the paragraph of the order, it specifically says the court did see a photo with a red mark on petitioner's bottom. However, her testimony along with the same did not appear to be credible. On page 5, the court did not make any mention about that she didn't seem credible. As I previously indicated, the court just mainly said that there was one picture of the bruise on the leg, and the court went on in reference to bond conditions that were pending. The court went on indicating to see whether Judge Morrison had an updated status in reference to that. The court went on in reference to advising the respondent to make sure he stays away because the bond conditions weren't modified. And so in reference to that, we take exception because that's not what the court's ruling was when all the testimony had been concluded. Additionally, on here it says petitioner would often refuse to respond to questions asked by respondent's counsel, and she would aggressively argue with respondent's counsel. She would turn her video camera off, and she appeared to be referring to something on her lap during her testimony, and she would argue with the court when asked to answer a question. Well, in the court's ruling, there was no mention in reference to my client turning on and off the camera off, or any mention of anything on her lap. We can't recall is that the respondent made a summarization of her closing in reference to that, but as we know, I'm not the trier factor here, nor is Ms. Lutton in reference to that. The judge, of course, is the trier factor in reference to the rulings and will identify specific facts and
okay, might scream too much
in reference to his or her judgment in any matter.
When I randomly go to a call,
this information
I've already covered the case they're talking about.
No, because that's not what the court's ruling was. It further says petitioner's demeanor and lack of cooperation or testimony, coupled with lack of sufficient evidence, led this court to find her claim to be unfounded. And again, Your Honor, we take exception to that because in the court's ruling that's attached as Exhibit A, there was no mention from the court in reference to her demeanor or lack of cooperation. What the court basically said was the court spoke about the bruising on the neck and not seeing a whole lot of proof in that. The court spoke about that there was a picture on the bruising leg. On page 6, on line 4, the court said, so she wouldn't say whether or not she lived in Georgia. Obviously, probably she doesn't, but she did not. She refused to answer that. The house is sold, that was a big thing. He doesn't know where she lives. There are still bond conditions, and there has to be a reasonable likelihood that violence will occur in the future. I don't see that. He has no idea where she's at. So in reference to anything more, the court did not indicate that in the court's ruling. And we're asking that all that information be stricken from
motion denied.
The final order pertaining to this dismissal of the temporary protective order. The law is very clear that in any type of motion to modify or amend or set aside the final order, that this court has the power to modify as long as it's in the same term. In this instance, this motion that petitioner filed was made in the same term. Pursuant to OCGA 15316, the court has the power to amend, control this process in order so as to make them comfortable to law and justice and to amend its own record so as to make them conform to the truth. C. Vaughn v. Fitzgerald, 112, Georgia, 517, 37 Southeastern, 752, 1900 case. What the petitioner is asking, Your Honor, is in the alternative that the court will adopt the petition that we had, or the proposed petition that we had presented to the court in reference to these findings in fact. In the petition that we had provided to Your Honor, we basically made a posture of the case in reference to the May 6th.
Kind of cute.
And I think in reference to doing a final order, and understanding that May 6th was part of that final order, there should have been some mention in reference to evidence, testimony, and otherwise.
Yeah, okay.
In my motion, I described that there was a lot of evidence in reference to exhibits that were provided by the petitioner. In addition, I talked about
This is all I didn't
the
agree with
testimony provided
the ruling
by
of the judge.
the officer
we know
that
that.
testified on behalf of Ms. Sullivan in this case. And I also identified the several incidents or occurrences in which Mr. Sullivan had appeared back onto the property on more than one occasion after the April 3rd incident.
Thank you, Queen Purple.
So if the court should not adopt the proposed petition that the petitioner, we're simply asking the court to just amend it to strike the information that I have indicated to the court regarding the final order, because that's not what was provided by the court's
this motion's getting denied.
pronouncement or ruling.
Just stay the hell out of the way.
All right, Ms. Litton, mazel tov on the union.
Judge.
All right, go ahead.
Yes, Judge. So Ms. Hood's entire argument seems to be that the statement of facts in the current final order should not stand and should therefore be vacated based on the fact that they were not specifically laid out in the verbal ruling. However, she's then asking this court to adopt her statement of facts, none of which are in the verbal ruling. Instead, it's all testimony and evidence that was provided throughout the hearing, as is the current statement of facts. I can specifically point out several pages where the court themselves actually stated and made mention to the issues that are currently set out in the final ruling. For example, page 69, Ms. Sullivan is asked several times to leave her camera on. It also occurred throughout the entire transcript. Page 70. She was told that she was refused to answer the question. She needs to turn her camera on. She needs to turn the camera to look at her face.
Clearly
Page
set forth.
87, the court made mention that she is looking at something and referencing something in reference to her testimony and what she's saying to this court. Not to mention, Judge, if you recall, you already made the decision. We're here on something where you already made a decision on. I provided my written ruling to the court through email, to which then Ms. Hood responded with her edits, where she quite literally copied the entire final order, deleted it, and then provided what she prefers to be the final order. The judge then reviewed both of our final orders and adopted mine. This has already been decided on. At this point, it is becoming harassment towards my client. I understand that Ms. Sullivan may have family and friends that are willing and able to represent her at a lower cost, if no cost at all. Mr. Sullivan does not have that opportunity. We are now here for the second hearing on this issue, as the first hearing had to be reset, and my client has incurred additional substantial attorney's fees trying to fight this frivolous motion. We are here today, and we're going to ask that Ms. Sullivan be ordered to pay his attorney's fees in the amount of $3,404, and I have my attorney's fees affidavit here provided to show what he has paid since the date that this motion was filed. That is what has been incurred from that date, to include 2 hours of my time today.
All right, and Your Honor, may I speak in reference to that? Now, opposing counsel has mentioned the 9/11 in reference to whether this was frivolous. This is not frivolous, Your Honor. This is based upon justification in reference to the true and accurate.
It's frivolous.
What the record reflect in reference to the court's ruling. And that's why we filed this motion, not for harassment, not to delay anything, but to speak the truth in reference to what the court said. You know, we are not objecting in reference to the significant pose of threat, because Your Honor did indicate that. But these other things that the opposing counsel had drafted in this order is not correct and is not accurate. And my client certainly has a right to file a motion in reference to making sure that the record reflects what's true and accurate in reference to what transpired
I just
by the
checked.
court. What did the court indicate? What were the facts that this court relied on and specifically said in its pronouncement? And as you can see, Your Honor, as part of Exhibit A, the court did not make any mentions in reference to what opposing counsel indicated in pretty much half of this paragraph. What we're asking is that at the very least, what happened to May 6th? There's no mention in reference to anything surrounding that. And then in addition, all of these things that she has identified in her paragraph or what her closing arguments were, which aren't evidence. And she is not the trier of fact. The court is. And the court made its pronouncement and the court made its ruling in reference to that our client, or that is the respondent, did not pose a significant threat. And these allegations further is not what the court said. In fact, there's, go ahead. I'm sorry, Your Honor. So in reference to my client paying attorney fees, that should not happen because my client had a right to file a motion
anybody sees it, put it in the chat
to make sure the record reflects what took place and what the court said. All we're asking is let the record reflect what the court said in reference to its ruling on that day. I attached the court's ruling. I attached what the court said on that date, and I'm just asking for Ms. Lutton to
thank you for a little sanity
or amend it to indicate what transpired from your pronouncement, not what she is arguing and what her closing argument. That's not what the court said.
Judge, if I may, first off, she's not arguing against me. It is not my order. It is not my final order. It is not what I decided to put into the ruling. The court already made the decision. The court got her proposed edits, chose not to go with her proposed edits, and made their final order put in place in this case. So I think it needs to be made very clear. It's not Ms. Lutton who she's arguing against. It's not Ms. Lutton who needs to amend anything. She's here today to argue that the court put in an incorrect and an inaccurate statement of facts in their final order. This has nothing to do with me. The court already made the decision. This case has gone on far too long. This case has become harassment against my client. And I specifically, although she tried to state that I didn't, I did specifically ask for attorney's fees in my response to her motion. We're asking that she be ordered to pay his attorney's fees. He does not have the ability to pay them because he has been doing nothing but paying attorney's fees against her for these frivolous actions and motions that continue to be filed against him.
All right, I'm going to let the final order stand as it is. Go ahead with your, you want to go ahead and testify about your attorney's fees?
Yes, Judge.
Well, that's not a good sign for Ms. Hood.
Robert, you have been incurring additional attorney's fees since the date that this motion is filed. Is that correct?
Yes, ma'am.
Yes. I'm going to share my screen and show my attorney's fees affidavit and bills and invoices, if you will. Is this a true and accurate copy of the attorney's fees bills that you received from my office?
Yes, ma'am.
Does it appear to be tampered with in any way?
Not at all. Not at all.
Okay. And is it correct that since the date her motion was filed, you have incurred additional attorney's fees in the amount of $2,704.13?
That is correct.
Okay, and are you asking as well that 2 hours of my time be added on to that for preparation today and attendance at today's hearing?
Yes, I am.
And so are you asking for a total award of $3,404?
Yes, I am.
Which I tender this as, I guess, just exhibit 1. And that will be my only exhibit.
Ms. Hood, you want to cross?
I do, Your Honor, but I'm taking exception in reference to this attorney fees. This is the first time, Your Honor, that I had an opportunity to review this. Opposing counsel had not provided me this the day before the hearing in reference to requesting attorney fees. She was
request
aware
on the
that she was
motion.
going to ask for attorney fees, and that I have not received this affidavit to even view, to look at it. So I'm objecting in reference to any information pertaining to that. In addition, Your Honor, as I said, under 9-11-15, just give me one moment so I can provide, Your Honor, the law in reference to that. 9-15-14 is.
I'm willing to send her the invoice now. It's 2 pages. I think she can review it today.
9-15-14 is for litigation costs and attorney fees, Your Honor, for frivolous actions. And that's something that the court will have to determine in reference to it. As I stand before the court, my client had justification in reference to filing a motion. She filed it within the same term of court. She indicated what exceptions that were not provided in the ruling of the court, which was again attached in the exhibit. That was complete justification in reference towards this motion to amend or modify. So in reference to attorney fees, again, my client does not have the funds. In fact, I'm doing this pro bono just to for justification from my client to amend this. So it's not like my client has a lot of money as well. She just started a job, and I don't even know whether she will be able to pay anything. In fact, I don't believe she could pay anything at all in reference to this. So I am objecting to any reference to attorney fees. This is the first time I saw this affidavit or report from opposing counsel. Opposing counsel, when this case was reset, she knew she was going to ask for attorney fees. Back in January, I never received any documentation for that to have an opportunity to review that information. I think it's unreasonable and unjustified for her to now produce it today, indicating that these are my attorney fees.
Well, I think previously in her testimony, she couldn't really get it straight on how much she paid in attorney's fees. She was like, 2, 3, 5. I think she finally said 5,000. She kind of went back and forth, and she didn't know how much she had paid in attorney's fees. So now she's never paid you anything, Ms. Hood, in attorney's fees?
Nailed it. I remember.
She paid me a little, Your Honor, but not a whole lot, $1,500, and I've been doing a whole lot in this case.
Oh,
so that's why I said pro bono is the only thing. I mean, I'm doing this pro bono.
Because I think
this motion to
in
amend
the transcript, it was more than 15, but now it's 15. Now it's pro bono. That's the problem. She has no skin in the game. She can sit here and file motion after motion after motion and not have any consequences for it. She's not paying for any of this. Mr. Sullivan just lost his house. He couldn't even keep his house out of foreclosure. He hasn't paid me anything. I am in the hole on this case. I'm not getting paid either. But he's certainly getting billed for it. And he's certainly getting billed for it. And he's certainly required to pay it. But Ms. Sullivan has friends and family who are willing to harass my client and file motion after motion, despite this court having already made a decision on this matter. It's ridiculous. It's absolutely ridiculous. She should not continue to go unscathed, to be able to file whatever motion she chooses to file. This was already a decision that was made by the court. First, it was that she paid $2,500. Then it was that she wasn't sure. That now it's pro bono. Well, now she's actually paid $1,500. Judge, it's quite clear she hasn't paid anything. And my client has been paying me over and over as much as he possibly can. And he's continuing.
No, that's not true. That is not true.
Ms. Hood, I'm speaking. She's continuing to incur attorney's fees on this case, which has become nothing but frivolous, and which I requested 9/15/14 in my response on the motion. He's entitled to attorney's fees, and we're requesting that he be awarded same.
Your Honor, 1915-14 regarding litigation costs states as such. In any civil action in any court of record of this state, reasonably and necessary attorney fees and expensive litigation shall be awarded to any party against whom another party has asserted defense or other position with respect to which there existed such a complete absence of any justificable issue of law or fact. Again, Your Honor, in your ruling, you never indicated any of that information that the petition that was drafted by the petitioner was provided by the court. The court specifically indicated that there was no significant threat. The court spoke about Georgia. The court spoke about, I didn't see any bruises on the neck. The court spoke about, I did see a bruise on the leg, but the court did not speak about all these other things. She had a right and a justiciable issue of law and fact that she could file a claim in reference to this. This is not based upon harassment. This is based upon just trying to get the record to speak the truth, to be accurate. And all we're doing is making an objection in reference to paragraph 1 in reference to it. The court cannot award attorney fees if it's not shown that we didn't have a justiciable issue of law or fact in reference to this Rule 9 side. And we're standing on the position that we did, that there was nothing attacked in that exhibit. Nothing in the Rule 9 side, nothing in the court's ruling in reference to that. There was nothing that the court said about the turn of video camera, arguing aggressively. She just didn't seem credible. There was no evidence of that in the court's ruling.
Again, we're talking about the court's ruling. There's a whole transcript of evidence and testimony that was put into the transcript.
One at a time.
If you read what she's requesting, you modify the order on, it's nothing but her statement of facts that she prefers to be put in, none of which were stated in the ruling. So her argument makes no sense. It's not justifiable. She's here to say that the statement of facts should not be in there because it wasn't stated in the verbal ruling. The judge can make any sort of statement of facts in their written ruling that they see fit. Not to mention, it is evidenced by the transcript.
Well, Ms. Lutton, that's incorrect.
Argument that she should not. That it
that's
should
incorrect in reference to the
judge. Don't talk over her, Ms. Hood.
She's then making the argument because it wasn't in your verbal ruling, it cannot be in the statement of facts. But then she's then providing a very lengthy statement of facts, none of which was mentioned in your verbal ruling. So I don't understand the argument. It's not justifiable, and this is harassment.
That's incorrect, Judge.
Anything else, Ms. Hood?
Judge, this case came before the court because there were facts that were specifically noted in the final order that was not presented by Your Honor.
Okay. I'll adjourn these to March 7th.
Thank you.
2023, 10:30.
Somebody say in the chat if she awards attorney's fees.
And that's before Judge Barr.
She did the right thing denying the motion.
Court calls the case of the people versus Eugene Ackland.
No, Williams for Superior Township.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ackland. Mr. Ackland, could you please state your name?
Eugene Ackland.
Mr. Ackland, could you provide an update as to what remains in order for you to be able to get a valid license?
That's what I do.
I'm still waiting to get a hold of the Secretary of State. I just got released out of county jail in the last month. And I've been doing my probation in class.
Okay, Your Honor, could we ask for an adjournment so that he can reach out to Secretary of State to get that appointment?
Okay, what I'm gonna do is I'll adjourn this to February 21st, 2023, 10:30. That's before Judge Barr. Mr. Ackland, I will let you know that you have
That's how I roll.
another warrant in another matter, drug paraphernalia case out of 14-2. So I suggest you get that clear. I'm not going to do anything on it, that you get that clear before you go see Judge Barr on the other day. All right.
I have a warrant for what?
It might be a failure to appear. I just handed the file off, but I think you got a failure to appear.
Possibly.
For what? Yeah, because I just got out of county jail. No, the other ticket I had was this.
There you go. Motion denied, fees granted.
And I just
Got a case out of the city of
That'll
Ipsy for
hopefully
possession
stop
of drug paraphernalia.
from continuing. This is the right roll there.
The offense date on it was back in December of 05. And it looks like the warrant was issued. I don't have the actual case file. I just had the printout. It was
in 05.
The warrant was issued, it looks like, in May 5th of 2006.
What?
So,
All right. What quarter is that out of?
14A2, City of Ipsy.
14A2? Okay, cool. I'll give him a call. Thank you. I didn't know that.
Thank you.
All right. Have a good one.
Court calls the case of the People versus Sparkleberry.
Will Williams for Superior Township.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Berry. Ms. Berry, could you please unmute and state your name for the record?
Sparkleberry.
Thank you. Your Honor, Ms. Berry does now have a permit. I did forward that to Mr. Williams. I'm not sure if he's willing to allow her to plead to a lower charge at this time or dismiss, or if he would like to adjourn until she's able to get a full license.
We'd be willing to adjourn.
I'll adjourn the matter out March 7th, 2023, 10:30 before Judge Barr on both matters.
Thank you.
Thank you.
You're welcome. Calls the case People versus Crystal Bryant.
Will Williams for Superior Township.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Bryant. Ms. Bryant, could you please unmute and state your name for the record?
We do not have her checked in. Bench warrant will issue for defendant's failure to appear. Hello. What's your name?
Yeah. This is Crystal Bryant.
Okay, now I have her. All right, what are we doing on this?
Your Honor, this is a matter where unfortunately, I believe it's going to take a little bit of time for her to be able to get her license back. She does have a lawsuit related to an accident. And so we were hoping to allow her to plead to a lower charge to get this resolved. And then she can take however long it takes to get those other matters cleared up.
The offer.
I don't know what that means. What are we doing?
Pleading to no ops on person.
Can you raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
State your name again.
Crystal Bryant.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of no valid operator's license on a person. That's a misdemeanor, punishable by up to 90 days of jail and a $100 fine plus court costs. You understand that?
Yes.
Understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You understand that,
I'm sorry,
ma'am?
repeat that? Yes,
You understand that by pleading guilty, you will not have a trial of any kind.
yes,
Because of that, also, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily and of your own free will?
yes,
And because you believe that you're guilty?
yes.
On February 7th, 2015, Prospect Road, Superior Township, Washtenaw County, State of Michigan, were you driving a motor vehicle?
Was I driving what?
Were you driving a car?
Yes,
Did you get stopped by the police?
yes,
Did they request a driver's license?
yes,
Were you unable to give them a valid license?
yes.
Counsel, have I complied with the court rule?
The people are satisfied, Your Honor.
The defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Ma'am, anything you want to tell me before I impose sentence?
I'm sorry, repeat that?
Anything you want to say before I impose sentence?
Yes, I'm really working hard to get this, resolved. I was laid off for a while, so it kind of, stopped a few things, but I'm working right now, so, and I'm able to get that in action. I only have, just trying to take care of that matter, and I got somebody who's working on that now. So I can
Fines
get
and
my
costs of
right.
fines and costs of $250. When can you pay that?
Can I have 2 months?
Pay it by March 31st, 2023.
Okay, thank you.
And I'll suspend 90 days in jail.
Thank you,
Thank
Your
you.
Thank you.
Welcome. Court
Thank
calls
you.
the case. You're welcome. Court calls the case. People versus Jamina Edmonds.
Bill Williams for Superior Township.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Edmonds. Ms. Edmonds, could you please unmute and state your name?
Good morning, Your Honor. Jamina Adams.
What are we doing?
Your Honor, I would like to ask for an adjournment in this matter. She had a ticket in Mason that she had to pay off, and she did get that paid. She also has a matter in Saline that she's working on getting cleared, and I believe after that, she will be able to get her license.
March 7th, 2023, 10:30, Judge Barr.
Thank you.
Yes, ma'am. Court calls the case. People versus Bonnie Gardner.
Bill Williams for Superior Township.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Gardner. Mr. Gardner, could you please unmute and state your name for the record?
He is present.
Can you hear me? Can you hear me?
What's your name?
Ronnie Lee Gardner Jr.
Okay. We got him. What are we
I'm
doing?
at work. I'm sorry.
Your Honor, Mr. Gardner did just get a new job, so he's now able to start working towards paying off his tickets. So we'd like to ask for a brief adjournment to allow him to make progress on that.
March 7th, 2023, 10:30, Judge Barr.
Thanks,
Thank
MC.
You're welcome. Gardner.
Hall.
Court calls the case. People versus Kenneth Hall.
Bill Williams for Superior Township.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Hall. Mr. Hall, could you please unmute and state your name for the record?
He's here.
Feel bench warrant coming on.
He's no longer here, but he was.
I was gonna say, I
He's
thought I saw
not
him.
here, but he was here. Rather than do a warrant, I'll adjourn this out to February 21st, 2023. 10:30 Judge Bar.
Gave him a break.
Thank you.
Hang on. Court calls case, the people versus Sidney Kellum.
Jamil Williams for Superior Township.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Kellum. Mr. Kellum, if you are present, could you please unmute and state your name for the record?
This is Sidney Kellum.
Okay.
Thank you. Your Honor, Mr. Kellum needs to make an appointment with the Secretary of State to get his permit, so we would like to ask for a brief adjournment.
February 21st, 2023. 10:30 Judge Bar.
Okay.
All right.
And I got another question. Can I pay off the ticket?
Pay off which ticket?
They gave me a ticket driving without license.
Sir, there aren't any fines or costs associated with this case as of yet.
Oh, okay.
Yeah, you see, you haven't pled guilty.
Thank you. Court calls the case, people versus Philip Kazuski, I think.
The beard.
Caddyshack.
Kaddyshack.
Yes, I knew. Anyway. There's gonna come a day I'll get it. All right, what are we doing on this case?
Have to.
Unfortunately, I believe that he has to go through the license restoration process. And so he is hoping to also plead to a lower charge today so that he can get this matter resolved and spend his time focusing on that more lengthy process.
Is that going? So is it going to extend its time frame though? I mean, I don't know.
I think that if anything, it's a 30-day extension, and I believe it's going to take quite a bit longer than that for him to get through that process. So,
all right. So what do we want to do?
The offer would be no ops on person.
Is that what he wants to do, Ms. Reed?
Yes.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record, please, sir.
Philip Kaddyshack, Your Honor.
Ooh, not that I know of, but
Sir, it
it'd be
is the
fun.
court's understanding that you're going to be pleading guilty to the charge of no valid operator's license on person. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes, Your Honor.
Understanding all that, still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind. You can put your hand down.
No. Yes, Your Honor.
All right. Because of that, you're also giving up your certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness against yourself or remain silent, not have that silence used against you, and you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
The beard is guilty.
On September 21st, 2022, Ridge Road, Superior Township, Washington County, State of
Ooh, that's
Michigan,
exciting, Jim.
were you operating a motor vehicle?
Yes, Your Honor.
Did the police stop you?
Yes, Your Honor.
Did they ask you for a driver's license?
Yes, Your Honor.
Were you unable to give them a valid license?
Yes, Your Honor.
All right, counsel, have I complied with the court rule?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to tell me before I impose sentence?
I am trying hard, Your Honor, to get my license back. It's just going to take time. Any leniency you could offer would be very appreciated. I don't have a lot of money, and I have 2 small children that I'm trying to take care of. And anything could help.
That was
Bouncing
well
costs
done.
of $250. I'll suspend 90 days in jail. When do you think you can get that paid?
Simple, appropriate.
30 days, then a month.
You think you can get it paid in that?
I have my tax return coming, so hopefully I should be able to pay it with that.
All right. How many people have you promised a tax return to? I'm kidding. Don't worry about it. Here's what we'll do. March 31st, 2022. 23, excuse me. Give you additional time. Okay, sir?
Thank you, Your Honor.
Thank you. Take care.
Have a nice day.
Court calls the case. People versus Janelle Manigault.
Mill Williams for Superior Township.
Silvana Reed, Assistant Public Defender, with and on behalf of Ms. Manigault. Ms. Manigault, could you please unmute and state your name for the record?
Janelle Renee Manigault.
Okay, Ms. Manigault, where are we?
I have my permit.
Huh?
I have my permit.
So you got back to that point.
Yes, sir.
We have a permit.
And
So
I
we
will
still
be
got to do
taking I gotta take the test, so I will be taking it.
Still got to do the driving test.
Yes, sir.
Okay, so her permit expired.
Okay, so when are we going to go do the driving test?
I was hoping next week.
When?
Next week. But if you could give me like 30 days, because I don't want to I knew you was gonna laugh, but I don't want to.
No, I am not. I told you I'm in this with you, so I'm laughing with you, not at you.
Okay. Well, thank you. And thank you for being patient.
Sometimes it's all I got. So here's what I'm going to do. I'm going to, before I have to move it to another dot, I'm going to adjourn this out to February 14th, 2023.
Oh, man,
9
2
a.m.
days before my birthday?
Valentine's Day.
Is that your birthday? 16th?
16th.
Okay.
Yeah.
All right.
Get your license
2
for
days
your
before your birthday on Valentine's Day. I have a feeling you're going to come back, say you parallel parked, you passed it, and your license is on the way.
Yeah, hopefully you have a lot to celebrate.
Yes. Thank you,
Okay.
Doug, for being patient with me. Thank you.
You're going to make it. You're going to make
Thank
it. So
you.
we'll see. We'll see you then, Miss Manigault.
Thank you. See you on the 14th.
Yes, ma'am.
Thank you.
Wah, wah, wah. Not quite yet.
Court calls the case of the people versus, is it Leanne J. Parker? Leanne J. Parker?
Mill Williams for Superior Township.
Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Parker. Mr. Parker, if you are present, could you please state your name for the record?
Okay. Now,
We don't have him checked in.
I was just going to wait for that, but
Bench
now I'm
warrant will
invested
issue.
in Lisa Reed and Kenneth
Bond
Cole.
5,000, 10%.
How you doing? I would like to say this is Kenneth Hall.
Who? Okay.
I think I probably missed
I think we already
my
called
phone.
your case,
Yeah, my phone.
but thanks
died.
for interrupting. On the Parker matter, bond is set at that amount. Warrant will issue January 27th, 2023. Court calls the case, people versus Reed.
Mill Williams for Superior
Court calls the
Township.
case, people versus Lisa Reed.
Lisa Reed.
Silvana Reed, Assistant Public Defender, with and on behalf of Ms. Reed. I believe that she is also someone who has to go through the appeal process with Secretary of State, and it is going to take a bit of time. And so she was hoping to plead to the lower no ops on person, get this matter resolved, and then spend the time that she needs to working on that appeal.
Correct, ma'am?
Yes.
All right. Is that the offer, Mr. Williams?
That
No
is-
ops?
Yep, that's correct, Your Honor.
All right. Mr. Reed, please raise your right hand.
She was.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Where are
State
you
your name
driving
again
to
for the
this call?
record, please.
Lisa Reed.
Ma'am, it's this court's understanding you're going to plead guilty to the charge of no valid operator's license on person. That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes, sir.
Understanding that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand that you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce
No.
you? You're doing this voluntarily and of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
I am.
All right. On October 24th, 2022, at the location of Ridge Road, Superior Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, I was.
And did you get stopped by the police?
Yes, I did.
And did they request a driver's license?
No, I just told them I didn't have one.
Oh, so they didn't have to request. You just didn't
No,
have it.
I let them know.
Seriously.
All right. And so you were unable to give them a valid driver's license.
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Your Honor.
Defense is also satisfied.
I don't know who that is.
Yeah, I thought we were going to get some
Court will
crazy
accept
there,
the defendant's plea of guilty to count 2. Count 1 is dismissed.
but didn't really
Ms. Reed,
materialize.
anything you want to tell the court before I impose sentence?
Yes, I just want you to know that I am fully guilty, fully, but I am working on getting my license. I haven't had a ticket in almost 15 years, so
Yeah, we know.
I'm doing everything that I have to do.
Okay. Haven't had a ticket except for this one, you mean?
Yeah, except for that one.
Okay. I was going to say, when did this
Now.
happen? Okay.
Right.
Fines and costs of $250. 90 days suspended. When can you get that paid, man?
Today.
Oh, okay. Thank you. He is working on it.
Yes, I am.
Okay. Get that paid today, then. And you're all set.
Okay. Thank
Take
you.
care. Good.
Well, what do you
Court
know?
calls the case. People versus Jawan Richards.
Camille
I
Williams.
want to read Assistant Public Defender with and on behalf of Mr. Richards. Mr. Richards, could you please state your name for the record?
Juwan Richards.
Your Honor, Mr. Richards has an appointment tomorrow with the Secretary of State for his written test. So we would just like to ask for a brief adjournment.
Turn the matter to February 21st, 2023, 10:30, Judge Barr.
Thank you.
Thank you. Court calls the case. People versus Jalen Thompson.
Camille Williams for Superior Township.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Thomason, could you please unmute and state your name for the record?
Jalen Thompson, not here. Bench warrant, 5,000, 10%. That warrant will issue immediately. Start right in on next block. Court calls the case, People versus Stephanie Garcia.
Jamil Williams for Superior Township.
Robert Getty on behalf of the defendant, Your Honor.
All right, what are we doing?
Your Honor, the people will be adding a charge of impeding and dismissing the original charge of failed to stop for a school bus.
That is correct, Your Honor, and I have the authority to accept that on my client's behalf.
And you do accept that?
I do.
Court will accept the admission to impeding traffic. Fines and cost of $180. When can that be paid?
Can she have 2 weeks to pay, please?
No. Yes. What's the end of? Having difficult. Hang on a second, counsel.
So today is.
I got it. Pay it by February 10th. Will February 10th work for you?
That works.
February 10th.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Mosa. Bella Mosa.
Jamil Williams for Superior Township.
Good afternoon, Judge. Attorney Danny Batty appearing on behalf of Mr. Mokbel.
Okay. Well, what are we doing?
Judge, I have not had an opportunity to speak with the township attorney, and that's my apologies. I had filed a motion. I thought that needed to be heard first, but I'm happy to get it resolved today, Judge.
Yeah, well, I can't let him out of the courtroom because he's got a bunch of other cases. So I'll give you time for you guys to use a thing called the phone. So I'll adjourn this matter to February 14th, 2023, 9 a.m. or as your Zoom invite indicates, and you guys can get it worked out between now and then. Thank you.
Thank you, Judge. I just looking.
Court calls the case, People versus Dewan Smith.
Jamil Williams for Superior Township.
Good afternoon, Judge Roger Cayley, P. 4811, appearing on behalf of Dewan Smith.
Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Dewan Smith here.
Okay. All right. All right. What are we doing on this? Question mark.
I was hoping Mr. Williams would have an offer for me. I sent him a.
All right, I guess we'll wrap it up there. I'm going to be disappointed, but I've got stuff I've got to actually get back to and do. Thank you all for coming out. I planned on doing this for 20 minutes, a half hour. I literally turned it on because I was having coffee and I had it in the background. I thought, why not stream it? And then we go all morning. We got Janelle, the cone killer, shows up. She's reinstated her permit, but does not have a license. And we, while they were on break, happened upon Lily laying down the law in Judge Manning's courtroom. It was more exciting than I expected, and there was some fun stuff in the call as well. But we did have a lot of people that were disappointingly reasonable. We had a lot of defendants behaving themselves today, but there were still some fun moments, as there always are in Judge Simpson's room. I don't know, what do I use for a thumb for this? Is this parallel parking number 468? Is this contentious attorney number 3? What is this? What's the thumbnail? Tell me in the chat. What's the thumbnail and title? Give me a good title. Your chest. Lot of talk with Mike. Your chest. There, take it. You'll get nothing and like it. Lily goes wild. Lily was on fire, but she was absolutely right. Good Lord, it was hard. First of all, that attorney Ms. Hood wouldn't shut up. Second of all, she's just sitting there blatantly lying. I watched the whole thing. And she just kept saying things that weren't so. Not only did I watch it, I've got it recorded. Tens of thousands of other people watched it with me. Don't tell me what happened in the hearing. There you go. There you go. It doesn't really matter. That was much longer than I expected, but a lot more fun too. Thank you all for coming out. I'll see you all soon.